Good evening, ladies and gentlemen. Welcome to today's edition of HR Mentorship Learning Series. Today, we'll be looking at a very important topic, and the topic we'll be looking at today is on understanding the application of international best practices in employee relations. Understanding the application of international best practice in employee relations. Today, we have a solicitor, a barrister, okay, by name, Mr. Emmanuel Abaraye, who is the team lead labor and employment practice group at Peckstone and Grace, which is one of the strongest law firms we have in Nigeria and of course in Africa. And he will be rubbing minds with us, sharing from his wealth of experience. But just because of some of us who may not know him, I would just like to read some excerpts from his profile, just so that we can get to meet him better and then he can take over the floor. Emmanuel is the team lead of labor and employment practice, like I mentioned, okay, at Peckstone and Grace, and is a core member of the firm's labor and employment litigation, intellectual property, startup, and banking and finance practice group. Okay, Emmanuel has, since his call to the Nigerian bar, worked diligently to develop competence in his chosen area of practice. He has been involved in many high-profile cases and transactions and continues to passionately pursue the interest of justice. I love that. He's a prolific writer and has published several articles and contributed to numerous journals. He's also a co-contributing editor to the Nigerian chapter of the Employment Law Review, a UK-based publication. He has also contributed to a number of periodic updates on varied spectrum of labor and employment law, not limited to diversity and inclusion in the workplace, workplace gender rights, and general employee rights. Okay, he is and other employment publications such as the Peckstone and Grace monthly newsletters on labor and employment law. We are very privileged to have with us today Emmanuel, who is a member of the Nigerian Bar Association and a member of its Young Lawyers Forum. He has also been proud to now to speak at various events, symposiums, and even radio and TV stations. Most recently, he spoke for the Chartered Institute of Personnel Management of Nigeria on Lagos Talk 91.3 FM, specifically the program, The Office, with so much joy and enthusiasm. Let's receive with warmth and virtual applause, Barrister Emmanuel Abaraye. You are welcome, sir. You have the floor.
Thank you very much, Mr. Adeosho. It's so great to be here. I'm happy to have been given the opportunity to speak to your audience today. Today I'll be speaking on the topic, understanding the application of international best practices in employee relations. I've set out an outline for today, and we're going to be taking all 6 items on the list, majorly 5. The last is really just the conclusion. We'll be defining all the terms we have for today. We'll be talking about the sources of international best practices, which you would find we have shortened to IBPs in the text. Well, not IBP as in high blood pressure, but IBP as per international best practices. We also will talk about why we need to apply international best practices in employee relations in Nigeria. We'll look at some of the practices that are currently prevalent in employee relations, which the courts have termed unfair labor practice. And then we would look at the international best practices that we can take out from the various international instruments we would look at in the course of this talk today, and how those practices apply to employee relations. Then we'll go ahead to conclude and then see what we can draw from everything that will be said today. So we'll define the terms. Employee relations is where we'll start from. And It's basically just the relation between employers and their employees, or even employees amongst themselves. It includes the plans and policies designed to support employee relations and their interests. Now, there are two types of employee relations as between employees. You have the vertical relationship and you also have the horizontal relationship. It's vertical when it's between superiors and their subordinates, and it's horizontal when it's on the same level, when the employees who are relating are on the same level. It can also be horizontal when employees are, relating amongst themselves, maybe whilst relaxing at the office lounge or whilst eating, when you really don't have that, command of superiority, it can then be horizontal. Of course, the goal of employee relations is to foster some sense of community within the organization, to initiate transparent workplace communication, to support the emotional, physical, and psychological health of employees, and ultimately create a positive employment relationship between employers and their employees that will eventually lead to increased retention, happiness, and productivity within the workspace. Then let's define international best practices. These loosely refer to principles and procedures that are accepted and prescribed as being correct or most effective in the Committee of Nations. IBPs for employment relations are mainly and usually found in international labor standards. These international labor standards are legal instruments that are drawn up by the International Labor Organization, which I'll subsequently call ILO. And they set out basic principles and rights at work. Now, in setting up these international labor standards, who are those people that are involved? You have governments, you have employers, and you have the employees themselves, or workers, if you would like to call them that. These are the people that make up what is called the ILO constituency. Now, in making up these international labor standards, which I have said you would find in international conventions, you have governments representatives, you have workers representative. For instance, in Nigeria, we have the Nigerian Employers Consultative Association, which is NECA. And then you have the Nigerian Labour Congress, who represents the interest of workers. So all of these persons are involved in the deliberation and decisions and drawing up of the policies and procedures which we say form international labor standards and are contained in international conventions. Now, even after they have drawn up these documents, it doesn't necessarily mean that any particular country would ratify what has been drawn up. But for every ILO convention you see, virtually every country was involved in drawing it up. Now, like I've said earlier, international best practices can be found either in conventions. Conventions are legally binding international treaties that may be ratified by ILO member states. You could also find international best practice in recommendations. Now, the ILO has conventions, recommendations, protocols. They have reports of the committee of experts. They also have the decision of their own administrative tribunal. All of these are evidence of international best practice. This is where you can draw international best practices from. Of course, though ILO recommendations are usually linked to conventions, because many times they are used to elaborate on conventions or explain how a procedure should be carried out, there are certain recommendations that are not linked to any convention at all. Now, it's not just ILO conventions that show what international best practices are. You also have non-ILO conventions, but conventions all the same that also, show us what international best practices are. There are 190 international labor organization conventions and 205 recommendations from which we can source international best practices. Now, apart from those ones, there are other international instruments that are not coming out of the International Labour Organization, but we can also find, international best practices in them. For instance, we have the International Covenant on Economic and Social Rights, which obligates state parties to ensure the right to work and earn a living is safeguarded. It also ensures fair and equal remuneration and, without discrimination, and also safety at the workplace. You also have the International Covenant on Civil and Political Rights, basically just prohibits all forms of slavery. You have, some ILO conventions that are on the point also. You have the African Charter rather on Human and People's Rights, which also guarantees the right to work as well as other basic fundamental rights. The ACHPR has been enacted as part of our Nigerian law as the African Charter on Human and People's Rights Ratification and Enforcement Act. Now, next is the Convention on the Elimination of All Forms of Discrimination Against Women, generally known as CEDAW. CEDAW guarantees the right to equal employment opportunities, free choice of profession, equal remuneration and evaluation, non-sanction for pregnancy and maternity, protection from harm during pregnancy. Basically, the convention focuses on women, as you can see in the name, and it's also a source of international best practices in labor and employment relations. Now, Nigeria has ratified 42 of the 190 ILO conventions. Now, of those 42 conventions, 26 of them are currently in force in Nigeria. Now, of the 26, Nigeria has ratified all the conventions that are considered fundamental ILO conventions. Now, there's just one which has been ratified, but be coming into force of that convention has been delayed, and there's a reason for that, but are not Forced Labor Convention of 1930. We have the abolition of Forced Labor Convention of 1957. We have the Freedom of Association and Protection of the Right to Organize Convention of 1948. We have the Right to Organize and Collective Bargaining Convention of 1949. We have Equal Remuneration Convention of 1951. We have Discrimination, Employment and Occupation Convention of 1958. We have the Minimum Age Convention and Worst Forms of Child Labor Convention of 1999. All of these are the fundamental conventions. Now, you also have two governance and policy conventions, which includes the Labor Inspection Convention of 1947 and the Tripartite Consultation International Labour Standards Convention of 1976. Then you have the technical conventions, quite a lot of them, too numerous to mention. As part of technical conventions, you have the Violence and Harassment Convention of 2019. It's going to come into force in Nigeria on November 8, 2023. That's later this year. Now, why are international best practices applicable in employee relations in Nigeria? I have earlier said and have listed all of those conventions that are applicable in Nigeria. Now, there's a reason why they are applicable in Nigeria. Section 12 of the Nigerian Constitution provides that a treaty can have the force of law, provided that it has been enacted into law by the National Assembly. Now, regardless of the fact that Section 12 provides that there has been an amendment to the Constitution, which is called the Third Alteration Act. Now, by Section 254C of the amended Constitution, there is an exception. Now, the National Industrial Court has jurisdiction in matters relating to or connected with unfair labor practice or international best practices in labor, employment, and industrial relations. Now, it also has jurisdiction in matters relating to or connected with or pertaining to the application or interpretation of international labor standards. Now, this is where the application comes in. The National Industrial Court itself has affirmed its power to apply international best practices in resolving disputes. Now, the Court of Appeal also, which is the final court in Nigeria as it relates to labor and employment matters. Of course, I know you know there is a Supreme Court, but when it comes to labor and employment matters, the Court of Appeal is the final court. So if you get a decision at the National Industrial Court, for instance, you only have an appeal, one avenue to appeal to the Court of Appeal, and whatever decision the Court of Appeal gives is final on the point. Now, the Court of Appeal has also held that the National Industrial Court has a duty and an obligation to apply international conventions and international best practices in the resolution of labor and employment disputes. Now, I have pointed out earlier that out of the 190 conventions, 42 are ratified by Nigeria. Does that then mean that the other non-ratified ILO conventions are not applicable? The answer is no. Now, the ratified ILO conventions operate as law, but you have the non-ratified ILO convention, which also apply as evidence of good practice and international best practices. The only difference is that to benefit from those non-ratified ILO conventions, a litigant must prove them in his pleadings to be able to rely on them. That's by virtue of Section 7, sub 6 of the National Industrial Courts Act. Now, aside the non-ratified conventions, you also have ILO protocols. Protocols basically are used to amend conventions. So whatever protocol is in force or has been enacted by the ILO is also an evidence of international best practice. Beyond protocols, you also have the reports of the Committee of Experts, which also are evidence of international best practice. Of course, the ILO Administrative Tribunal is basically like a judicial arm and hands down decisions from time to time. And those also can be evidence of international best practices. Now, we've had situations where lawyers have gone to court to say, there is this practice that prevails in South Africa, or there is this practice in Mexico, or there is this practice in the United States of America. The question has now been, are those practices also international best practices simply because they apply in more developed countries? The answer to that is no. And there's a recent decision of the, well, not so recent decision, was handed down in 2019, where the NICN held that the Swedish Ordinance of the National Board of Occupational Safety and Health did not apply as an international best practice to the claimant's case. So what are we seeking to as international best practices. It is simply what the International Labour Organization has set as international labor standards. All of this you would find in conventions, in recommendations, in protocols, in reports of the Committee of Experts, and also to a large extent, decisions of the ILO tribunal, administrative tribunal, interpreting some of these conventions. Okay, so what? We have all of these documents, international documents, which we claim are evidence of international best practices. What then happens to the contract of employment? Is it not sacrosanct? The contract of employment does not trump international best practices, especially when the provisions of that contract negates international best practices. Of course, you cannot necessarily contract your way out of law. Law is law. There are certain laws that would allow you contract yourself out of them, but not all laws. Now, law itself, one of the definitions you can give to it is that it is the prophecies of what the court will do and nothing more pretentious. We would like you to know that the National Industrial Court will enforce international best practices, whether it is enforcing it as law because it has been ratified by Nigeria, or it is enforcing it as evidence of good practice and has properly relied on it. So because the National Industrial Court will enforce international best practices, we can then say that international best practices are applicable to employee relations in Nigeria. Now, the NICN in a number of cases has struck down contractual provisions that contradicted IBPs, that's international best practices. Contractual provisions that run afoul of international best practices are themselves evidence of unfair labor of the National Industrial Court, where the court has held outside the practices are applicable. Now, before we go on to list some of the international best practices, of course, I've already said that there are 190 conventions, 205 recommendations. If we're going to sit here and list out all the international best practices that we can draw from all of these conventions, we won't go home. We'll probably be here for another 2-3 days, just taking breaks and coming back. But maybe if I have the opportunity to come back next time, I'll expand and take you through all this. But I'll take you through some of the things I consider the most common in employee relations, where some companies or employers have been held liable because they breached international best practices. But before we get there, because there are international best practices, there are the opposites of what international best practices are. And that's what we know as unfair labor practice. Now, you recall that I had said earlier on that section 254C sub 1 has given the National Industrial Court the power to determine unfair labor practice. Now, but unfair labor practice itself does not really have a strict definition. Yes, we can say unfair labor practices are those practices that negate international best practices, that breach the contract of employment, that demean the employee, that breaches the rights of the employee and all of that, or even the employer in some cases, because And the complaint has always been that labor and employment laws seem to be too employee-centric. That's really not the case, but it's usually the argument that is made. Now, I will take you through a number of cases where the court has decided certain things and said those things are unfair labor practices. You'll be shocked that some of you are doing them in your companies, but thank God you have an opportunity to hear this today. It's an unfair labor practice, and I'll list many of them now. So now in the case of Mr. Olabode Oguntale and 64 others versus Globalcom, the court listed 4 things that it said constitutes unfair labor practices. Now, failure to issue written particulars of the terms of an employee's contract. Basically, if I'm putting this simply, you are failing to issue a contract of employment. You have taken someone through your onboarding processes, interview processes, and then you have decided that you're going to hire them, but you fail to give them a contract of employment. That's an unfair labor practice. Now, stopping the issuance of pay slips is an unfair labor practice. Failure to allow your employees go on annual leave or to even pay leave allowance and overtime allowance is an unfair labor practice. Very, very unfair. I mean, someone is not going to work the whole year, does not go on leave, does not rest, nothing, and then you think you're going to make heaven. Now, if you compel your employee to bank with a specific bank, you insist that your employee must bank with XYZ Bank Limited, it's an unfair labor practice. And I'm sure some of you are shocked to hear that, but it's actually an unfair labor practice. Let's go forward. There's a case of Sunday Chukwubai versus Ajuba Nigeria Limited and another. Opening virtual salary accounts for your employees is demeaning of those employees, and it is an unfair labor practice. Maybe I need to explain what VSAs are. So you have a situation where an account is opened by a company. None of the employees who are drawing from that account can actually be said to be the owners of the account. So they have no account opening documents to which they can lay claim to. They only just have debit cards. So for instance, the company pays 5 million naira into the VSA, and every employee has a limit that they're allowed to withdraw with their ATM cards or with their debit cards. And they can't even track what their spending is. They can't prove anything through that account. The court says, no, that's an unfair labor practice. It's demeaning of the employee. Then there's another case of Leonard Oyibo versus Guinness Nigeria PLC. Dismissal on false allegations. You just want this person to go. So you decide, well, you stole. And then you cannot substantiate the allegation, and you just dismiss the person based on a false allegation. And I'll tell you why this is important as we go further. Dismissing any employee on a false allegation is an unfair labor practice. Then there's a case of Agatha Honora versus Access Bank PLC. When you dictate to an employee where to invest his or her earned gratuity benefits, it is an unfair labor practice. Beyond just earned gratuities, because of course, if you follow what happened, I think sometime last year, I don't want to mention the name of the organization, but it was a lot, and employees came out online and were revealing certain things they were forced to do. Some of them said even their ESOPs, that's stock options, employee stock options, which they were given by the company. they were forced to sell at a particular price, which the company imposed on them as against what they had in the relevant documents, vesting the ESOPs on them, that's the employee stock options on them. That itself is an unfair labor practice. Moving on, there is a case of Miriam versus University of Illinois Teaching Hospital, where the court said vindictive suspension or vindictive denial of promotion is an unfair labor practice. So you just want to revenge, maybe as HR, you were walking into the office one day, you saw this particular employee, they didn't greet you, you asked them, oh, you didn't greet me, and they looked at you and they just eased and walked away. And in your mind, you will see, I will do you back. Then a performance appraisal comes and you decide that you will not promote that person, not because the person's performance is poor, but simply because the person did not greet you. That's unfair labor practice. Of course, there are some companies who have what we call the Unity Bank clause in their contract of employment, where they say they reserve the right to reject resignation. It's an unfair labor practice. You cannot reject someone's resignation, else you'll be forcing that person to work. And that itself contravenes the provisions of the Forced Labor Convention. It's an unfair labor practice. In fact, you should know that once an employee has resigned, of course, there are dynamics to it, and there are certain things you might want to consider. Sometimes an employee has been involved in a gross misconduct, and then he finds out that, oh, they're going to take disciplinary actions against him. He quickly sends in his resignation. And then you as HR, you feel this is unfair. Why would he, just decide to leave? If you decide that what you need to do in response to what has been done by that employee is to refuse to accept the resignation, then that would be an unfair labor practice. Doesn't mean you don't have a remedy. We'll get to that at the relevant stage. You do have a remedy, but you cannot exercise any kind of discretion on an employee's decision to resign. There's a case of Adesanya Adeyemi Joachim versus Union Registrars Limited, where the court said termination of an employee's contract of employment on grounds of trade union activities is an unfair labor practice. So you have this employee, and of course, if you've done HR practice for a while, you find out that union people can be very interesting, very, very interesting, and they can be, I don't want to use some kind of words, but you cannot terminate a person's employment simply because they are involved in union activities. If you do that, it will be deemed to be an unfair labor practice. There's a case of Aja and Fidelity Bank. The unfair labor practice there is employees being subjected to retroactive policies so as to deny them of accrued benefits. And I would give you an example. So an employee has worked in this place for, let's say, 15 years. You had a policy in place where you said if someone achieves 15 years in an organization, then they'll be entitled to XYZ amount of money as gratuity. Then you find out that it's looking like you've shot yourself in the foot, and that you have a lot of employees who have spent that amount of time with you, and the financial burden is becoming heavy. Then MD calls HR. We need to do something about this thing. Let's see how we can reorganize and reduce this liability. Then HR comes up with a document that says, oh, now, even though you have spent 15 years with the company, your XYZ amount is now ABC, reducing it. Now, except the employee consents to that reduction, which of course none of us will do, except the employee consents to it, it's an unfair labor practice. Now, Okojere and EcoBank was where the NICN held that where a bank places liens on an employee account, it's an unfair labor practice. Now, there's a decision in Victor Banjo and Institute of Directors, where the court held that withholding terminal benefits for failure to attend an exit interview and providing a handover note, especially where same was not provided for in the contract of employment or handbook, is an unfair labor practice. Now, this is where HR practitioners need to be very careful. If something is not in your handbook, you cannot just decide to take an action on it, because your handbook is what defines what can govern the relationship between you and your employee. Whatever name you call it, whether you call it employee handbook, whether you call it employee relations policy, or you call it industrial relations policy, or you call it staff handbook, management handbook, whatever name it is called, those documents have to be exhaustive enough to define what the relationship between the employer and the employer should be, so that when any action is taken, you have a point of reference to say, okay, this is the document that states what cannot withhold the terminal benefits of your employee's exit interview process, or that they didn't give a handover note. Now, that's also say the preparation and submission of a handover note is not crucial. Absolutely it is. But there are times when you would know, or you should know, that certain things are what we lawyers would call a cause of action separate from what is currently happening, and which you should pursue as an independent cause of action of its own. So if you find yourself in a situation where an employee is leaving, you need them to submit their handover notes, you also need them to submit to an exit interview, and they are refusing to do it, it's not ground to withhold their terminal benefits. In fact, terminal benefits must be paid within a reasonable time after termination of employment. And of course, what we call pylon, that's payment in lieu of notice, must be paid contemporaneously with the termination of employment. Because when I say contemporaneously, I mean it must be paid the same time as the person has been terminated. Next is the case of Barrow and Polaris Bank, where the court held that refusal by employers to issue work reference after employees exit is an unfair labor practice. Now, I'll tell you a live case, and I can discuss this case because it's already in public. We had handled a case for a bank, and there was an employee who had done, some things that she wasn't allowed to do by virtue of the employee handbook applicable to staff members. And for bankers, termination is a serious issue. And of course, if you're terminating someone for a particular reason, you also have post-termination obligations as an employer to the Bankers Committee and also the Central Bank of Nigeria. Of course, you know that sometimes the character of those who work in the bank is quite crucial. As you know, you don't want your money to be missing and all of that. So this lady did certain things, and then she was to be fired, but someone in the HR team quickly tipped her off that, oh, they're going to fire you, so I advise you to tender a resignation. Then she tendered her resignation, and after she tendered her resignation, about 6 hours later, the letter of termination got into her email. Then, because the internal workings of that HR team was a little bit, I don't know how to explain it, but someone else in the HR team now abandoned the termination letter that had been served and went ahead to accept the resignation of this employee. Then a more senior HR personnel issued another termination letter and said, this, what exactly should we do? All she wanted really was an exit letter because she wanted to continue work, and she slammed the bank. Especially because the bank could not really point to anything that the employee had done wrong. So what did she then have to do? She applied to court and said, compel my employer to give me an exit letter, which the employer was not inclined to do. But then the bank had to reach a decision. Okay, she's entitled to an exit letter. Give her an exit letter, especially because you did not, act on the disciplinary issue the way you should have acted on it. So because there was a fault in the disciplinary procedures, the bank was punished for it. And well, the only good news from that case was that they didn't have to pay 1 billion naira in damages, especially because the claimant could not prove that she had suffered any loss on account of, whatever it is she was complaining about. Now, let's move on. So you also have a practice where employers hold on to the certificates of their employees as some form of a guarantee for good behavior during the employment period. That is an unfair labor practice. It's totally wrong, and everyone should jettison that kind of practice. We move on. Now we have said all of the things that we have now found to be unfair labor practice. Mind you, we are not just calling all these things unfair labor practices just for the sake of it. They have, liabilities that follow them. So if you have done certain things which are unfair labor practices, and the court finds that indeed what has been complained of amounts to unfair labor practices, punishment or punitive damages will follow, or damages would follow. Damages is really just the monetary liability you have to pay to the person you have wronged or to the employee you have wronged for the unfair labor practices that you have meted out on them. So it's not like you would go there, the employee would go to court and the court would say, oh, this is an unfair labor practice. And then you just say, okay, yes, there was unfair labor practice, everybody go home. No. Some of those things that are found to be unfair labor practices have been punished with damages, ranging up to millions. I mean, there is a case that was decided in 2022, early 2022, where the claimants went home with about 125 million naira for certain unfair labor practices that were meted out against him. So really and sincerely, unfair labor practices are not things that we should joke with as HR practitioners or as in-house counsel, depending on where you are. Now let's move on to international best practices that are applicable to employee relations. Now, like I said earlier on, the conventions are so much, we cannot list them all. We also cannot exhaust them today, maybe another time, but I'll just take you through a few of them, especially the ones that are, very common things that happen. I'm sure some of you must have watched movies where an employee does something wrong and then the employer just shouts, "You're fired." And then the employee goes, packs their things, they put it in a box, and then they start going out of the office, and their friends are crying, and they themselves are crying, and everybody's feeling sad. Um, that is not the way people are fired. And if you've been doing that in the organization, you need to change and repent, because that's an unfair labor practice in itself and can cost you a lot. So I'll take you through a list of things. Let's start with performance appraisals and probation. Of course, we know um, when you employ somebody, you place them on probation for a period of time. You want to know, is this person really a right fit? Yes, you have interviewed this person. The person seemed to have done really well, and then but you really don't know, is this person really a right fit for my organization? Um, is there something that can be done better, and all of that? Then you employ the person, put the person on probation. It's okay. For the next 3 months, for the next 6 months, you will be on probation. We will confirm your employment at the end of 6 months or at the end of 3 months, as the case may be. The employee starts work. After the 6 months, can you just decide that, look, we didn't find you a good fit for our company. We don't want you here anymore. Please leave. The answer to that is no. For terminations that are based on performance, whether it was during probation or whether it was, we can excuse probation, but if it's termination done after confirmation, you must give that person the opportunity to improve on their performance. Must. You really cannot just decide that you are terminating the person and let everybody go to their various houses. No. You place the person on what we call a performance improvement plan to show the person the areas of their work where they have been defective, and then you give them an opportunity to improve on their performance. If you terminate without giving that person that opportunity to improve, that termination will be deemed wrongful and not in accordance with international best practices. Yes, then we've already started talking about termination. Termination must be with valid reasons. Valid reasons. If you terminate an employment without reason, so here's this what we see very often when we go to court. Services no longer required. No explanation, no nothing. Just say services no longer required. Then the person, sues the company, and then the company comes to us, and then we tell the company, you also have given a valid reason. Now, this is why the exit procedure is quite important. If you find that an employee, for instance, is performing poorly, you have to place him on a performance improvement plan so he improves. This part of giving the opportunity and the employee an opportunity to improve is as in Article 7 of the Convention 158. Convention 158 is the Termination of Employment Convention of 1982. Now it has a recommendation following it, which is the recommendation 166. Recommendation 8 of that recommendation and Article 7 of the convention, when you combine them, it gives you a procedure. Now, Article 8 says don't terminate him for his performance if you have not given him the opportunity to defend himself. This is the word defend. Recommendation 8 says don't terminate him until you have shown him what he has done wrong and you have given him an opportunity to improve on that performance. Then you can go ahead and terminate the employment. If you have terminated without that, that termination is wrongful. Now, if you're terminating someone for poor performance, you must state the reason for the termination.
your performance was poor. Now, but if you don't follow the procedure that I have earlier said, and you just go ahead to say your performance was poor, so we're terminating your employment, you would find that that's wrongful termination, and it also leads to civil liabilities. So you must give a valid reason for the termination of an employee's employment. Now that's Article 4 of Convention 158. There are certain things that in international best practice or international labor standards are considered not to be valid reasons. If you terminate someone for union membership or participation, or for standing for elected positions in any workers representatives union and all of that, it's not a valid reason. So the termination is going to be wrongful. If you terminate an employee, for instance, who whistleblowers, that's wrongful termination. If you terminate an employee because on a discriminatory ground, it's also wrongful termination. If you terminate an employee who was on maternity leave, and this is quite important because it happens a lot, and I know that sometimes the hands of HR practitioners are tied because the management has said, do this, and it's what you just feel you need to do. The person has given birth, and there's, the amount of time they need to be given after giving birth so that they can, regain, strength and all of that. And then you terminate at that point in time. That's an unfair labor practice, and it's capable of putting you into civil liabilities. We move on. Discipline and dismissal. So I had said earlier on that Article 4 of the convention says you must give valid reason. Article 7 also says you must allow the employee to defend himself. Now, when you have made allegations, for instance, you've issued a query to an employee, and that is eventually going to lead to the dismissal of the employee, you must give the employee an opportunity to defend themselves. If you do not give them an opportunity or opportunities to defend themselves, the termination of the employment will be termed wrongful termination. So you must therefore give employees the opportunity to defend themselves against allegations. So you've issued a query and you've served the query on the employee, you must give them an opportunity to respond to the query. When you give them the opportunity to respond to the query, then you can then take whatever decision you want to take. But in taking that decision, you must show that you have considered the responses given by the employee and that you have exercised the discretion to decide whether or not the responses are satisfactory. In which case, you can decide, okay, you said enough, we agree with you. Yes, we can look away from this now because you have proved yourself, so you exculpate them of any wrongdoing. Or you find that their answers are not satisfactory enough, in which case, you have to take a disciplinary decision. Then you decide that, okay, your punishment for this is termination. If you haven't followed through with what is expected of you, you'll find that if you just go ahead and say you stole and so we're terminating your employment, of course, nobody drafts employment or termination letters that way, but just giving you an example. You stole and so we're terminating your employment. The question you would face when you get to court, if the employee challenges that termination, is what's the proof that he stole? What query did you issue to him to give him the opportunity to defend himself? To find out that he didn't give any query, he didn't have an opportunity to defend himself. You just heard that he stole and you went ahead and fired him. That's an unfair labor practice. So you must give employees the opportunity to defend themselves before you take disciplinary actions. Of course, disciplinary actions are not limited to termination. It could be suspension. It could be, a stern warning. It could be whatever it is you have stated in your handbook or employee relations policy. But whatever it is, you must give the employee an opportunity to defend themselves. Now, when it comes to misconduct or gross misconduct, employers must act quickly. Recommendation 10 of recommendation 166 says you must act quickly. You cannot say that there was this allegation against Chukudi or against Yemi or against Shola in 2014, and this is 2023, and then you raise it up, and then you issue him a query for what happened all those many years ago, and then you expect him to defend himself, and then you then terminate his employment because you had a brainwave, he did this thing that time, the time when they were first of all trying to bring Buhari into power, because that's what you can use to remember what he did. The time has already passed. So it will be deemed that whatever wrong he has committed, you have condoned it. So you have to act quickly. Now, how about when an employee raises a grievance or whistle blows? If an employee raises a grievance, Article 5C of Convention 158 requires that there should be some form of protection from retaliation, from intimidation, from victimization, from unfair termination. Of course, sometimes, and I'll give you an example. There's the case of Sharon Philip and Notori Chemicals Industries Limited. There was a whistleblower report. It wasn't even the employee that reported the issue, but there was a fact-finding investigation was carried out, and then they set up a panel, and then they invited employees to say what they know about what happened. And then this lady came and then said, well, this person did this, that person did that, and this other person did that. And those persons somehow got to hear that this particular employee was the one who reported. And they were her superiors. They then started, retaliating. In fact, it got to the point where the lady found herself being without an office in that particular place. She didn't have any role, she didn't have any job description. And then later on, her employment was terminated. Now, she went to court and, people were wondering, okay, what exactly should be done in this kind of situation? And the court said, look, you as the employer have the obligation to protect her from those persons she has whistleblown on or, revealed certain facts about. You could have moved her to a different department. You could have found a way to shield her from retaliation, but you did not shield her from retaliation. Therefore, this termination of her employment is wrongful and constitutes an unfair labor practice. So if there's been a grievance that is raised, raising grievance simply just means that an employee has been wronged. And I'll give you another instance of a matter that we handle at the National Industrial Court against one of the ride-hailing companies. They had, employed this person the person was resident in Canada at the time. They had employed him, but he's a citizen of Burkina Faso, right? Had a very interesting name, which even I cannot pronounce very well, but I believe I'm pronouncing it well when I say his name was Sheikh Ouedraogo, right? He comes to Nigeria, working for the ride-hailing company, and then he resumes, and then the country manager asks, oh, what's your name? And he says, my name is Sheikh Ouedraogo. And she goes, oh, then I'll just call you Drogo. Yeah. So if you watched Game of Thrones, you know that Drogo was a barbarian character in Game of Thrones. And the guy said, no, I don't want to be called Drogo. You can call me Sheikh, or you pronounce my surname well if you want to call my surname. My surname is Ouedraogo. Now, the spelling of that surname is Ouedraogo. Let's all agree that it can be somehow, dicey to pronounce the name. But the country manager went on calling him Drogo. And so he raised a grievance to her, telling her, look, I don't want to be called Drogo. My surname is Ouedraogo. She wouldn't listen. She continues calling him the name. He then reports to a second line manager. I have been constantly called this name by this person. I do not like it. He refused to intervene. Then when the country manager found that he had escalated to a more senior person, she started targeting him, and then started retaliating, took out some work from him, and gave him work that were junior and made him report to his subordinates and all of those kinds of unnecessary things. Anyway, the court found that you cannot call someone with sub-requests if the person is not happy with it. So people like me, for instance, I get called Biggie a lot because as you can see from your screen, I'm almost filling the entire screen. So most of the time I get called Biggie. Do I like it? Yeah, I don't care about it. I'm big. It's but if there's someone else who says they don't like to call that sub request, then don't call them that, because it can actually be seen that you have you know breached their employee rights. Anyway, so if an employee raises a grievance or an employee is whistleblowing, they must be protected from retaliation. They must be protected from intimidation. They must be protected from victimization, and they must be protected from unfair terminations after raising the grievance. Now, let's move somewhere else. Another area that we can see is an international best practice. Freedom to unionize and have workers' representatives. You cannot decide in your company that you do not want workers' representatives, you don't want unions. If your workers decide that they want to aggregate to have a common voice, please do not interfere in the slightest way, even by trying to help them form a name for whatever they want to be. Do not do it. Leave them to form the unions by themselves. You cannot say, oh, don't come and call yourself Ajangbadi Union in my office. So it's spoiling the name of my office. We are posh people here. We are truth. We don't do that. You cannot interfere. So it's a fundamental principle in the world of work that employees should, without distinction, have the right to establish and join organizations as unions of their own choosing without interference by either the employer, management, or by even the government. That you would see in Article 2 of Convention 87, which is the Convention concerning freedom of association and protection of the right to organize, came into force in 1948. Of course, there are decisions of the Nigerian courts on that point. Quite a lot of them were cited, just Nest Oil PLC and UPenn. Now, health surveillance. Of course, you know that sometimes you need to know if your employees are medically fit to be employed for certain roles. So, to an extent, even in the international labor standards allow some form of health surveillance, but you cannot use it for discriminatory purposes or in any manner that is prejudicial to your employees' interest. Now, that's Article 11, Sub 1C of the Convention on Occupational Health Services of 1985. I'll give you an example. We put on this case that you're seeing on the slides, Adewumi Akinola versus Ocean Marine Solutions Limited. Quite an interesting case because in that case, the employee, she didn't know she was HIV positive, right? But at some point, she was asked to go for tests. She was working in the kitchen of this particular company, and then she was asked to go for tests. And then she went for the tests. Turns out she was HIV positive. They didn't tell her at the place where she went for the test that she was HIV positive, but they sent the results to the companies in a sealed form. And then all of these things started. They stopped her from working. Somebody leaked the information about her HIV status to other employees. She began to be ostracized by the other employees. Nobody wants to go near her. Nobody wants her to serve them food. And then, it got to the point where she was just terminated. And, well, it so happened that the employee decided to go to court. And then the court looked at it and found that the termination was unfair, especially because we have a law and anti-discrimination against persons living with HIV law or act, because it was enacted by the National Assembly, that requires that you do not discriminate against persons living with HIV. Of course, we know that there are concerns around this, and it's the reason why one has to be careful when it has to do with a health matter. You don't treat it lightly, and HR practitioners have to be very sensitive about how they treat employee data, especially medical data. And we don't expose certain information to other employees. This is why, of course, as you would know, HR practitioners have to be very discreet with what they do. So yes, health surveillance is allowed. You can monitor the health status of the employees, but it must not be used for discriminatory purposes, and also must not be used in a manner that is prejudicial to the interest of the employee. I know that this particular point is going to raise questions, so I'll leave it until then. Let me go to the next aspect. Now, health and safety, of course, we know what happened with COVID. Oh, should we, some of us who took the vaccine, I was so shocked to find that there are so many people who expected us to die. It wasn't fair, but people, projected dead, don't take the vaccine, your blood is going to clot, you're going to die of cardiac arrest. Well, for those of you who didn't suffer COVID, you don't know what the Lord did for you. I suffered COVID and I thought I was going to die. Thank God I did not die. I mean, if I died, I wouldn't be here. I mean, if I had died and you are seeing me here, you also go and ask Mr. Adeosun of questions of how he was able to get me here in my death state. But I mean, I didn't die, but I had to take the vaccine. But it was a big issue in some companies. Do you want to take the vaccine, or do you want to be subjected to, periodic tests? And those tests were not fun. They are painful though. Some of you can go and share testimony of not having to go through that. But it was a big issue for some companies. They didn't know what to do. They wanted employees to be vaccinated because they have an obligation to keep the workplace safe. So employers have the overall responsibility of ensuring that as much as is practicable, they prevent, they have preventive and protective measures to minimize occupational risks. But then you then have employees who decided that, look, we're not going to be vaccinated. It's an antichrist thing. They want to inject us with 666. It's against my religion. I'm not going to do it. Okay, fine, you're not going to do it, please. Take this test that will let us know that you are not, you've not contracted the disease. So we can allow you into the office, or even follow the simple measures, wash your hand, wear a face mask. Did you guys see some people's face masks? Some people were reusing face masks for like 2 weeks, and face masks were getting darker than their faces, and they weren't changing it. That itself was another occupational hazard that the offices were not ready for. But there's that. Now, what's an employer supposed to do in instances like this? The international best practice there is that you have to keep the workplace safe at every point in time. Now, let's move to the next one. And I'm trying to speed up now. Let's move to the next one, redundancy. Of course, what are you supposed to do? Article 13 of Convention 158, of course, you know that redundancies could happen for a number of reasons. It could be that there's an economic challenge. There could be a technological advancement that has made your work obsolete. We are all talking about ChatGPT and the AI and the effect it has on our work today. All of those things are real life issues that can affect people's jobs. So what happens if there's been a technological advancement that makes your job unnecessary? What is your employer supposed to do? Now, it's a very tricky issue because a lot of reliance is placed on national law and practice. Now, the national law and practice for this is Section 20 of the Labour Act. Section 20 of the Labour Act requires that you negotiate with the workers' union, observe the principle of last in, first out, pay some form of redundancy benefits to the persons who have been affected by the um, redundancy, which is of course the same thing, well, largely similar with what the Article 13 and 14 of Convention 158 says should be done. Now, but what then happens? Because there are some employments or some companies where you don't have unions. Now, if your employee handbook already states what you should do in the event of redundancy, and this is why having an employee handbook is quite important. So your employee handbook can actually say that in the event of redundancy, we will pay you every 3 months salaries as compensation, or maybe we'll pay you 1 month salary for every year that you have worked with us. However, it is your couched it in your employee handbook. If you have a non-unionized employment and you have provided for what should be done in the event of redundancy in your handbook, that goes. If you haven't done it, if you don't have a handbook or you did not provide for redundancy provisions in your handbook, then you have to fall back to what is international best practice. Yes, you recall that I talked about resignation at the beginning, or at the early stages of this talk. Now, this is the case I told you about. I was the one who was counsel in this case. I lost the case, so that you not come and call me Ubunge lawyer. Unfortunately, in this particular case, I was not a Ubunge lawyer, but I saved the company from paying 1 billion in damages because that was the only thing I could do. I've already explained to you why that was. Of course, we had a situation where, the employee was terminated and she needed a work reference. Now, even if you do not have a procedure in your handbook that says you must give work reference to your employees, please, the position of the law is that it is an implied obligation in contracts of employment for you to give work references to your employees when they are leaving. Now, the work reference you give to them must be a fair and accurate depiction of their time with you. And it's tricky because some employees are very interesting. And sometimes you just have to be careful. We had to advise a financial institution recently. They had hired somebody and then found out that he had been terminated in his previous place of work, and it was also a financial institution, and those people did not escalate to the central bank. Of course, there is a blacklist where they would, put in your name and then no other person can employ you. So work references are important because you cannot lie that someone was good when they were bad. You cannot say someone was bad when they were good. You cannot use work reference to witch hunt somebody. So they must be fair and they must be accurate and they must depict, what the circumstances of the person's employment was. We're coming down to the end. What's my recommendation now that I'm concluding after, we've gone through this lengthy ride together? Employers can be forward thinking. They can incorporate international best practices into their employee relations policies or their employee handbook, and even in collective bargaining agreements, so that you don't, people are not placed in a situation where you are already at breach from the day the person started, their work with you. Employers should also strongly consider having a legal officer who is trained in labor and employment law as part of their HR team. Now, this is not to discredit HR practitioners in any way. I know a lot of HR practitioners who keep up to date with the decisions coming out of the National Industrial Court, and it's quite important. That's the next thing I have recommended, that the decisions of the National Industrial Court should be followed keenly, especially as it relates to international best practices or how international best practices have been applied in deciding employment matters in Nigeria. So if you're not following the decisions, you won't be able to know what the discussion is now. For instance, we had looked at the case where somebody was leaving and he didn't prepare a handover note, and he also didn't submit to exit interview. And then his terminal benefits were withheld. And then the court said that's an unfair labor practice. You see? So if you're not following the decisions of the National Industrial Court, you will not be able to know what is happening now. The National Industrial Court is your court as HR practitioners. Don't leave it to lawyers. Yes, we are the ones who go there every now and then, but the decisions are available online. It's nicnadr .gov.ng, I think. Yes, nicnadr.gov.ng. So you go to that website, you would see judgment. You can follow judgment by the years, you can follow judgment by the months, you can follow judgment by the divisions of the court. We have Lagos Division, we have Abuja Division, Enugu Division, Yola, Akure, Kano. I've been to a number of those divisions too. You can follow all the decisions of the court. Lastly, employers should hedge the risks of being on the wrong side of a civil claim by seeking legal counsel from labor and employment law experts before taking action that would eventually be deemed to be wrongful. So thank you very much. I'll now, Mr. Oliemi, over to you, sir.
Thank you so much, Barrister. At least there's something I can call you, you won't sue me for. I can find out of a truth, you are Ogbonge lawyer. That was a really exciting session. Definitely, you have to come back. We will take that up. You have to do second term and third term and fourth term, as the case may be. You can already see hands up. Ladies and gentlemen, now that we know a little more about unfair labor practice, permit me to also say, if you are not applauding, showing relevant emoticons and emojis is an unfair participant practice. Thank you. So if you don't mind, you may want to stop sharing your slide.
Yes.
If you also don't mind, you want to scroll through the chat box, you will see some questions and comments. You may want to respond to some of the questions. You may also want to react to some of the questions as you like. But while you scan through, so just a minute, just keep scanning through. I would like to take some feedback or questions or comments. The first hand I saw up was for Demola. Demola, if you can hear me, I've given you access to unmute.
Okay, sir. Thank you very much, sir. I really want to appreciate this session. For one, I was able to get something of the importance of work reference and also the AI part. So the AI has been one of the major tools I've been using. And the moment you mentioned work reference, I just went to the AI and I said, create an AI form using my name for the bank I work with and my office. And I saw that, and I saw the response again, and I'm like, wow, within 2 seconds or like 3 seconds max, it gave me the answer I needed. And though I think my organization do give it out, but it's not something I would do like consistently. We just do it upon request. But seeing it now, I think it's something that we need to now do. Especially for people that resigned and not people that were terminated or people that had issues in the office. So, and I was able to learn a lot of things when it comes to. There was even one that he spoke about giving sack letter to people while the maternity leave. I had to say wow when I did that, because I actually did that to someone. And when he said that point, I was like, wow. So what we did was actually unfair. Because even though there was a fourth case, the lady was partly involved in the fourth case. So it was as if it was done unjustifiably. But for the fact that before that we did it while she was on maternity leave was enough to justify that we didn't actually do the right thing. So I really want to appreciate you, Mr. Bani, for fantastic session. And I'll go on to YouTube to watch it again. Thank you, Mr. Lumidi. God bless you, sir.
Yeah,
Thank you very much.
Thank you so much. We'll take Oluchi now, then we go to Apology. I'm calling in order of how you raised your hand. so that I will not be accused of unfair moderation. Oluchi, please unmute.
I have. Good evening, everyone.
Good evening.
Thank you so much for the session. I want to find out, there are some organizations that have this thing called retained terminal benefits. They include it in the employment letter where they, some percentage of the money, the employee salary is removed, not statutory deduction. It's called retained terminal benefits. Quote and unquote, they said they are encouraging staff to save or by force savings, but some say actually it's like if you destroy something, willfully or unwillfully, they will use it for to make up for whatever was spoiled. So I don't know, that retained terminal benefit, is it right? That is one. Then the second one is, you mentioned something about keeping certificates. So I asked, what if it's the company that maybe they send the person abroad for training and the certificate comes and the organization keeps it? Is it still unfair because they sponsored and took care of the flights and the logistics and all that? Then thirdly, you talked about termination.
Oluchi, please. Please, I don't want you to, this will be unfair monopoly.
Okay.
Two is okay. Two is
But
okay.
it's like,
So, the third one, type it out. We go to Abolaji now, then
Okay,
Barita will
good
take
evening.
all these questions all together. Hello,
Good
Abolaji.
evening. Yeah, good evening. My name is Bolaji Shote. Thank you for this session. It was quite insightful. I would like to ask you two questions. The first one is, I already typed it, but I think it might just be great too. What do you do in an organization where there are no policies? And it's just easy for, since there are no policies, the management keeps flipping, you know, they do it to their advantage to flip. What do you do in that kind of an organization where there is really no policy? What do you hold on to when there are issues for such organizations? The second question I want to ask is, how do you handle an issue with an employer who is not in a country? You want to take up something legally, an unhealthy work practice or unhealthy work treatment for, you worked with the employer out of the country. And I mean, they've flaunted a lot of things. How do you take it up with them to ensure that, I mean, you get a redress from such an employer, knowing fully well that it's not a Nigerian company and is also not located in the country? How do you address this kind of issue? Thank you.
I don't know if I can address the questions that have been asked so far. Okay. Okay, let me just go ahead and address the questions that have been asked so far. The first question was about retained terminal benefits, and then whether they can also use that to offset liabilities coming out of damages that the employee might have done to the business. Well, so here's the thing. When they told you that they are helping you save, did they tell you that they would also use the money to offset, losses? If the answer to that is yes, then there are certain things that, hedge against the extent to which they can go in making those deductions. To start with, if something is termed your retained terminal benefits, whatever has accrued to you as terminal benefits cannot be, reduced in any way. You are entitled to that fully. Nobody can take out of it for any reason. But then there's the provision of Section 5 of the Labour Act, which allows employers to make deductions in certain circumstances. One of those circumstances is where the negligence of an employee has resulted in loss to the company. But you cannot deduct more than 1/3 of the employee's monthly emoluments. That is what the law says. So if they've kept aside money for you, the law does not allow them to take more than 1/3, which is 33.3% of 1 month's salary. So your retained terminal benefit has already accrued to you. For them to now say, oh, this is what was done at one point in time, and then will deduct from your salary is an unfair labor practice, which the court would definitely frown at. And of course, there will be punishment to follow. I hope that answers the question adequately. Then, of course, keeping certificates because you sent an employee abroad and all of that. Well, was there a bond that the employee signed that says that they would not be, they must work for the company for a number of years? Now, this is the way it works. There are several decisions of the National Industrial Court on the issue of employee bond. It is not just that it's going to be at large. The amount of money you have spent must tally with the number of months or years that you want to keep the employee. And of course, the National Industrial Court will always, honor employee bonds. There's no, an employee cannot just wake up one day and say, okay, he's running out. In fact, there was a decision that was delivered in just January of 2023 on the point. The guy had been trained by Overland Airways, and then he just decided after his training that he was going to leave Overland Airways and then go somewhere else. And the court said, no, you can't go somewhere else. If you want to go somewhere else, you have to pay back that aspect of the sum spent on you that has not been used up. So let's say they spent $20,000 on an employee, and the employee would ordinarily earn that $20,000 in, let's say, 18 months, right? And then he has worked 6 months with the company, and then he wants to leave. Because then calculates how much has been used up. So employee, if you want to leave, no problem, but pay up what is unused, in the bond that you have signed with the company. And the next question was about what you should do when there are no internal policies in a company. Yes, it is why we have talked about international best practices today. In fact, there cannot be policies that employees would. A company cannot have policies that run afoul of international best practices. Like I've told you before, that itself is evidence of unfair labor practice in itself. So if there are no internal policies in a company, there are international best practices that can guide. Yes, I know it can be confusing. Employees don't know what to do. You don't know, okay, what should I do if I need to go on a compassionate leave? For instance, I'm not feeling fine. What are the steps I'm supposed to take? Nobody has said anything about that. Nobody has any written document that says, so everything is just anyhow in the company because nobody knows what to follow. Mind you, even companies where they have internal policies, many times the company doesn't even know what the internal policy itself is, so it's a lot. But of course, there are international best practices to guide what should be done. Now, what should you, as an employee who is working there, do? Well, do you have a contract of employment? What's the extent of your contract of employment? What does your contract of employment decide? Right? What are your rights and obligations under that particular contract of employment? Even if you don't have an employee, sometimes the contract of employment might be so detailed. I've seen contract of employment running into 27 pages, 32 pages, 35 pages because they want to tailor policies to suit certain class of employees. And so they don't have a general handbook. So, that might be the case. Now, when your employer is outside the country and they wronged you, well, it depends on what the kind of job is. And probably that person would have needed more clarification. What's the nature of the job? Is it a platform work? Are you doing it online? Like for instance, those who work with or those who drive, that's with the ride-hailing companies, Uber, Bolt, the rest of them. Yes, they might even have Nigerian outposts here in Nigeria, but of course, the parent companies are outside the country, some in Europe, some in the US. So that particular question needs some form of expansion for me to be able to give a proper answer to it. So I don't know, Mr. Joshua, I don't know if I can. I'm seeing a hand up, so I'll just wait for your guidance.
Yes, let's take question or comment from Stella Odubumi. Stella, if you please, if you are still with us.
Okay, good evening, Mr. Emmanuel. Thank you for the session. It was really insightful. And thank you, Mr. Yemi, for this privilege too. Okay, so I want to ask a question. I think somebody already mentioned that, but I want to add more questions to it. So she mentioned, what do you do in a company that doesn't have any policy, and a company where, for instance, you have contract staffs that their contract has elapsed, but you're not saying anything about it, and they're still working, you're still enjoying everything, and nobody is saying anything, and everybody is just moving on like that, and there is no policy, there is no handbook. It is just the company is just going, wake up one morning and let's just go there. That's how it is. So what do you do when you are in that kind of company? Thank you.
All right. So let me just even quickly say that HR practitioners, so you're hearing there's a lot going on. A lot of companies don't have internal policies. Well, so here's just the thing. If you have, for instance, a situation where an employee has been employed to be on probation for a number of months, right? The number of months have been fulfilled, the company doesn't say anything. It is deemed that that employee has been confirmed. So you cannot just keep an employee on probation, because I see sometimes in court, some lawyers make this argument that, oh, this person was employed in 2014. However, at the time of his leaving the company in 2022, he had not been confirmed. That argument doesn't hold water. The moment the period for your probation has been completed and you have not confirmed that employee, that employment is deemed to be confirmed. In the instance of an employment that you found that, oh, well, is this person supposed to be in a fixed term contractual employment, right? And he has, the company has not said anything, the term for the employment has lapsed and nothing has happened. Well, that employment is deemed to be continuing, right? And whatever should accrue to the employee for the period of time he has worked. So, for instance, the company cannot turn around to see, oh, we did not renew your contract, so you're not entitled to salaries from this period to this period. No, the employment would be deemed to be a continuing employment. So whatever should accrue to that employee within that time space is definitely entitled to. You cannot rob him of it. Okay, I see Mr. Dubu wants to probably give further. I see your hand up.
Okay, so I'm going to move further. And okay, so I mentioned that you have a contract staff where nobody is saying anything, but it was stated that, okay, for this your probation month, you're going to be paid so and so amount, and it's going to be, and the money is good. They're going to have to add more to it. Well, it wasn't stated before the probation, but it was stated that by the time you're done with the probation and we are fine with your performance metrics and it's above average, your salary will be increased. But now you said salary will be increased, but my contract is over. Even if it is deemed to be continued, you're not saying anything. So you're still on a payroll of being as a contract staff or being on probation. Do you understand? I don't know if I have to do you get what I'm
Yes, I
trying to say?
understand you. I understand you.
Okay.
So here's the thing. The moment the probation period ends, and it was stated in your contract that your salary will be increased, and they continue paying you that old salary, you actually have a right to claim the unpaid aspect of your remuneration from the company. No doubt about that. Now, even if it was not stated in your contract of employment, but it is a practice in the company that when an employee has been confirmed, the salary will be increased from A to B. there is a legitimate expectation. We call it an expectation interest, but it's a legitimate expectation that has been created in favor of other employees by virtue of the earlier practices in the same company of paying employees a higher sum upon confirmation, that I also, upon confirmation, be entitled to the same payment that other employees have or were held to be entitled to based solely on the principle of legitimate expectation. The principle of legitimate expectation is the effect that if you have created a practice that other employees or other persons are expected to rely on to earn a benefit, you cannot turn around to say, no, I didn't promise you that. It was only A, B, C, D that I promised that thing to. No, you can't say that. By the principle of legitimate expectation, other employees would also be held to benefit from that. So it doesn't matter that they have refused to pay. In fact, we had, and of course, as employees, you also must speak up. So many times, one of the challenges we have when we go to court on behalf of employees is that there is nothing in writing. You just come to say, oh, this, so there was no claim before the time you left the company. So for instance, you cannot stay in the company for 15 years, and then after 15 years, you remember that 14 years and 6 months ago, they promised you that they were going to pay you XYZ amount of money extra, which you should have earned for 2 years within the 15 years period. It's tardy. I don't know if you understand. It's not so it's best for you to have, all your grievances in writing. Even if there is no employee policy within the company, it's always best to have your grievances in writing so that when we want to claim international best practices, that okay, this employer has breached international best practice, this is what they should have done that they didn't do, the claim would have a basis upon which it can, stand. So I hope that answers the question.
Okay, thank you so much, Barrister. We'll take 2 more voice questions, and that will be all. Then you respond to all inquiries on the chat box. Let's take David. David, please be brief. Please be brief. You are empowered to ask your question, David. DI, please, can you put on your camera? I need to confirm your identity. DI is a little dicey.
Okay,
Hello,
thank you very much.
Yeah.
Yes, thank you very much. I just have a situation that I would love some clarity on.
Okay.
I have an employee who was employed and on a project, happens to be the head of a particular team on a project. Then all of a sudden, the owner now said, no, you are not really doing well to my capacity. He was given some privileges and accesses. All of a sudden, they were all withdrawn. Then I redeployed him to another project, but not as a head of a team this time around. Is it proper for me as an employer to now come? He was on X Naira before now, and I said, okay, this time around, I can't be paying you that same amount as you are earning when you are the head of that particular team. Now I am going to be paying you a reduced salary. Is it proper? Is it a good practice to do? So that's my question. Thank you.
All right, thank you very much. So it's not a proper practice. Let me explain it this way. The position is that if you're going to vary the terms and conditions of any person's employment to the extent that they would now be receiving lesser than they should, that variation of the terms of their contract must be with their consent. In fact, what the ILO has said is that there should be, social dialogue, same thing as what has been called participatory democracy, meaning that the employee must have a voice in that decision you are taking to either reduce his job role or to reduce his remuneration. And again, if you joined us earlier on, you'd find that we had said that before you can take any decision relating to an employee's performance, you're saying, oh, you haven't performed as well as I would have wanted you to perform. and so I'm not pleased with you. You must give that employee the opportunity to improve on that performance. So the employee must be given an opportunity to improve on his performance. And of course, in practice, what we do, or what HR practitioners are expected to do, is to place that person on the performance improvement plan. Anything else that you do, you reduce their salary, you terminate their employment, you will deploy them somewhere else, and they have to be earning lesser than they actually already earn. All of those things will be termed to be unfair labor practice. So yes, you found out that the employee was not performing as much as he should. The first thing you should have done was to place him on the performance improvement plan, give him an opportunity to improve on his performance. Then if he's still not improving, you have the opportunity to terminate his employment, or you can then speak with him. Look, ordinarily, I want to terminate your employment. Not that you're going to advise him to resign, no, that's constructive dismissal. You're telling him, ordinarily would terminate your employment, but recognize your need to work. Do you want to consider taking this other opportunity? And of course, you have to hedge against any risk so the employee doesn't come back tomorrow to say so many things happened, this one happened, and then that one happened, so I'm suing you. You know, is why even your exit processes must be managed with things like MSAs, mutual separation agreements, and the rest of them, just to make sure that you don't have any risks that you're running with that. But if you're going to reduce an employee's salary or his remuneration, or you're going to redeploy him and he has lesser job functions, it must be with his consent. And of course, I'm assuming that this scenario you've painted is not a independent contractor person that you just gave work to do, and then he's coming for a project, and it's not like he's employed by you. It's just an independent contractor coming to work. That's a different scenario altogether. These rules of employment law do not apply to that other aspect. So I hope that answers your question.
Thank you so much. We'll take the final contributions or questions for tonight. Go ahead, sir.
Hello, good evening.
Good evening, ma'am. Daisy, good evening.
Good evening. Thank you so much for the insights. Thank you. Okay, my question basically is brief. What do you do after an employee resigned from a former organization? I mean, proper resignation, termination was, exit interview was done, everything was fine, but there has always been a tiny lingering issue about pension. While the employee was there for 3 years and 2 months, pension was never updated or paid. There was always an excuse of collation, same thing, and the employee resigned. 2 months after resignation, no update on pension, no update on what's going on, and I mean, same old, and the employee is looking to, taking the organization to court or something, or doing something just to, get the benefits that as accrued to the employee over time. Thank you. What do you
very much.
That case? Yeah.
Yes. So here's the thing: your employers have 7 days under the Pension Reform Act. They have 7 days from the period when they deduct your employee's contribution from your salary to remit that contribution. If they fail to do that, they have committed a crime under the Pension Reform Act. But the fact that it's a crime is one thing, because that's criminal prosecution. You, as an employee, you are still entitled to both the employee deduction and the employer's contribution of your pension from the employer for the number of years that you worked with them. So you are entitled to it, no doubt. So what should you do? Sue them. And I know that many times when lawyers say sue them, people then say, you're concerned, you don't want to burn bridges and all of that. Look, that's the judiciary, as they say, is the last hope of the common man, right? So sue them. the court will then compel them to make all those things. It's your entitlement. You've worked for it over the years. You're supposed to have gotten it. They have not paid it to you. You can, of course, start by writing to them. This is what, of course, a good lawyer knows how to write a strong worded letter that will scare the hell out of them. Of course, upon receiving the letter, they might move and do something, but some people just like to be taken to court. And then they are taken to court, the court will order them to pay. And then they would have no choice but to pay. But mind you, it's already a crime. And you can actually petition the Pensions Commission, and that's PENCOM, the National Pension Commission, right? You can petition them to inform them about what has been done. The pension, of course, the Pension Commission can then, as the complainant, take up criminal proceedings against them. That's one. But you, regardless of the criminal proceedings, are still entitled to your pension. So you claim that through a civil proceeding at the National Industrial Court. The court will compel them to pay to you. So you just have to sue them one way or the other. Criminal, civil, you just have to sue.
Thank you so much, Barrister. I just don't know if you don't mind to just check the chat box. Maybe there is anything you want to respond quickly. We are not taking any more questions. We need to wrap up in the next few minutes. I don't want Mrs. Ruth Abraye to sue us.
All right. I have seen I've seen a number of questions. I'll just quickly run through some of the ones I've seen. I'm seeing this. A staff of mine was on suspension. He resigned immediately. His salary was paid while still on suspension without handing over. He mentioned in his mail that he's waiting for his pension, but up to now I didn't pay because he didn't give any notice to his resignation, nor handed over. So you recall that we had said something about this. You cannot retain employees' entitlement simply because there is a post-employment obligation you are waiting on them to fulfill. You have a right to sue them for any breach of, post-employment obligations. You should not hold on to their entitlement simply because you want to use that to compel them to take a particular action. Recall that we looked at a particular case against the Institute of Directors, where the Institute of Directors has refused to pay someone's terminal benefit because he did not submit to an exit interview and also did not prepare a handover note. And the court said, look, that's unfair labor practice. They were damnified in cost and damages. So you don't want the court to, because look, you will still pay what you don't want to pay. And then you now pay additional damages on top of it. I don't think anybody should go through that. But there's a valid point you have raised, and employees do it a lot. And I said it at the time when we started. They know that they've done something wrong. They get suspended, they quickly resign because they don't want to be disciplined. Now, an employee who does that forfeits certain of their benefits. Like, for instance, if they had resigned honorably, they would have probably you could have paid certain things to them, right? They forfeit it. They forfeit certain other terminal benefits, of course, minus statutory things like pension. You don't touch that. The law says you must remit, so you must remit, so you don't touch pension. But an employee who refuses to submit to disciplinary procedures forfeits their benefits. So it's not like you would decide that you would then hold on to this and then you're playing some kind of game and let's see who would hold on the longest. No. So that's why it's also very important for you to have employment policies to help you hedge against this thing. Tom said in the case where it is stipulated in the employee handbook that the company does not support unionization, but the employee goes ahead to join one, how does the HR handle this, especially if this gets serious and is leading to a court matter? Look, no company can tell their employees to not unionize. It breaches one of the fundamental conventions of the ILO. It also breaches national laws. You cannot, in fact, I said earlier on that there's a case of Nestor versus Mupeng, where I said the court held that, look, even the slightest interference with a union is wrong. So you cannot interfere with an employee's right. They have a right. It's even a constitutional right. They have freedom of association. They are free to join any association of their choice. So you cannot stop them. If you do, you will be putting yourself in harm's way. So looking at okay, I don't know what this is saying.
So let me just chip this question in on behalf of someone here, sir. So what do you
Okay.
have to say, generally speaking, around maybe organizations saying a lady must spend 2 years before they get pregnant, or must wait 2 years before they become pregnant after the last pregnancy, those kind of gender bias stuff?
It's an unfair labor practice. You see, the provision, so that's why I was saying earlier on that even if the convention in question is not an ILO convention, and it's not one that is ratified by Nigeria, so long as it provides procedures and principles that employees can rely on, it's applicable. So there's a convention on the elimination of all forms of discrimination against women. That convention is very exhaustive on all of the things that can affect women in the workplace, including telling them, giving them a timeline for pregnancy. You can't do that. If you do that, it's an unfair labor practice that is actionable. And I must tell you, one of the challenges I think I have found is that many times when even people who are my friends or colleagues are facing certain challenges at work, and they call me and they call my wife, who's also a lawyer, they've not written anything. They've not said anything. Some of them are leaving it for God. They don't want to make trouble. And you hear all the kinds of things that are being said. And you wonder, why are you not taking any action about this? It's just a little forbearance. And you get something out of it at the end of the day. Yes, I know. Court cases can take forever sometimes. On the average, at the National Industrial Court, 18 months, thereabouts. But you will get something at the end of the day, and you will put other people where they should be, so that people coming behind you don't face the same thing that you faced. So there's the case of ADK Maduka versus Microsoft that we still celebrate today. It was a sexual harassment case, and you see, many times people think that it has to be the big things. Look, even if someone is poking your shoulder or touching your butt or touching a part of your body you don't like, it's harassment and it's actionable. And you see, judges hate because already you know that the dynamics at play in an employer-employee relationship is such that the employer has the higher hand, and people who are in management in any employment are seen as also the employer. So you cannot have a situation where you're just suffering in silence. No, you shouldn't allow that. No employer can tell you how you should get pregnant. It's an unfair labor practice and it's actionable. So there's a question here that says, should disciplinary action on employees have effect on their performance appraisal, like deducting some points for performance score based on misconduct? Yeah, unfortunately, this is one of those times when I must say yes. I know that for almost 2 hours now, I've involved in employee. Employers also have rights, and some of the actions of employees can also be deemed to be unfair labor practices. It is not just the actions of the employers that I'll give you an instance, right? Someone found out that he was going to be fired, and in the office where he was working, they had paid him to get some kind of infrastructure ready, and he did it with not just only him but his entire team. And when they were going to fire him, he just deleted everything, deleted it deleted it from the cloud. And this is something the company had spent hundreds of thousands of dollars building. That is an unfair labor practice on the part of the employee. So if you have a situation where you have done some wrong, there's been a misconduct, they queried you, they found you wanting, there has to be consequence. If the consequence for that thing is the deduction of points from your performance appraisal, then it's correct. This is what you should note. Whatever is the punishment for the action that you have done wrong must be provided for in the policy document. Now, punishment cannot just be discretionary, that the person will just look at you, oh, it's looking like you are well fed. Okay, we'll take out half of your salary, we'll pay you half of your salary for the next how many. No, whatever is going to be the punishment for anything must be provided for in the handbook itself. And that's the only thing that can be done. Another question says, hello, Mr. Emmanuel, should the work reference be given to the employee upon resignation, or is it upon request from the new employer? Give it to the employee upon resignation, wherever he's going to. Sometimes the employee will come back to you and say, XYZ person is looking for a work reference. Or upon submitting the work reference you gave to them, the new employer would look at your address or your email information and then write you saying, we received this as work reference from so and so person. Please confirm that this work reference is accurate. In which case you have an obligation to confirm. If you do not confirm and the employee loses the job, you have wahala, because you will then be the one to face the music. Someone said, okay. Please, in a situation where a company provides employees for another company and an employee was accused of stealing and had his employment terminated by the company that they were outsourced to, if an employee takes the case to court, who will be the liable company that outsourced? Is it this company that outsourced or the client? So this is a triangular employment relationship. In triangular employment relationship, you have the end user, you have the outsourcing company, and then you have the employee. Now, the way it works is that the end users would normally leave those issues relating to discipline, termination, and all those things to the outsourcing company, because for all intents and purposes, they want it to be that the outsourcing company is the one exercising the control over the employee. But when you have a situation where control is being exercised also by the end user, because sometimes there's a co-employment relationship that is created sometimes in some of these instances, and the end user is also exercising an extent of control over the employee. Then, if the employee has been terminated or they take some disciplinary action against the employee, it's a matter of choice. The employee can decide that if I sue this outsourcing company, when they won't get, they will not give shishi. And then they decide that, well, let me go after the big fish. It's dicey because the Court of Appeal just gave a decision in Logguard Limited. Some employees had sued Total, and they were trying to get the court to say that Total was their employer. But in that decision, even though some of us don't agree with that decision, the court said, no, you're not Total's employer because you couldn't show us documents that proved that you were actually employed by Total. But co-employer status goes beyond that, way beyond that. So you could find yourself in a situation where co-employer relationship can be determined even if the other person in the mix did not give you any onboarding documents, did not give you employment letters and all of those things. It could still be determined that yes, because of the extent of control, so there's a control test that is carried on to determine whether one person is to be liable or not. So it all determines on it all depends on that control test. Maybe I should take one last question. Is it okay for HR to pick up position at the union level? Thank you. Well, so unions as they work is usually dependent on the profession. Now, HR generally, they don't join any of those unions. So for example, if you have a food company, usually Tops and NUFBT, right? The HR cannot say that she can be a member of Tops or NUFBT because she's not in that line of work. His HR work. So It's not just something that you can decide that since there's a union, I also want to be part of the union. And if, for instance, the HR person is a senior employee in a management role, right? The Trade Union Act does not allow management employees to unionize. They are not one of those kind of employees that can unionize. Unionization is left for junior and senior employees who are not in management. So if the HR person is on the management role, then they cannot unionize. But even unionization depends on the profession. So if you check the Trade Union Act, the schedule to the Trade Union Act lists who the professions that can be under a particular union. So if your profession is not part of the professions listed for that particular union, then you cannot claim that you are a member of the union just by choice. Your rights of association is also circumscribed by law. So I believe that helps.
I think if you don't mind, sir, there's just one more question. Is at the base of the chat. It's from Leticia. I suspect that Leticia may keep malice with us if we don't respond to her question.
Okay, I've seen it. Okay, I said, okay, let me just read it. I know we're not discussing PMS here, but in the spirit of fair practice, I would like to know if it's okay to deduct employee's salary by 30% for poor performance and credit another employee 30% for exceptional performance. Please note it's a quarterly appraisal system that whichever side of the coin you find yourself affects the next quarter. Well, let me start like this. You cannot transfer remuneration from one employee to the other. It's wrong. Now, what every person has worked for, they have worked for. You cannot now rob Peter to pay Paul, or however they say it. An employee's remuneration is something you are contracted to give them personally, not as a group thing. It's personal, you know. So when you have contracted to pay an employee a particular sum of money, that employee is entitled to that sum of money that you have contracted to give them. You cannot say, oh, your performance was poor, so you remove 30% and give it to XYZ person. The only time when deductions are permissible is under Section 5 of the Labour Act. And even then, I would use the provisions of Section 5 advisedly, because the Labour Act is also limited in scope. Yes, some persons argue that it's a prescriptive law, and it can apply beyond the scope. But Section 91 of the Labour Act limits the application to manual workers and those doing clerical work. But Section 5 of the Labour Act is the part that allows you to deduct employee salary when they have been negligent and the avocation lost to the company. This doesn't seem to be the case here. Here you are saying that, oh, your performance was poor, we'll deduct 30% and give it to. There's no transfer of remuneration in employment law. So that practice is, again, an unfair labor practice. What you do when performance is poor is you give the employee the opportunity to improve on that poor performance. And if they have not improved, you can exercise your discretion to terminate that employment, not to take out of their salaries and pay someone else. That's totally an absolute wrong. I don't know if that answers the question for Leticia.
Thank you so much, Barrister. Before I celebrate you once again, I want to report some people on this platform. They have people like nannies, gate men, drivers. I'm not sure they've been treating them very well. Some of them, their nannies don't go on leave. Please, these things we've been speaking about, does it apply to people like cleaners? I mean, domestic or at home?
It does, absolutely, it does. So the thing is that so long as you are in an employment relationship, so you know that we talked about some fundamental conventions. There's a convention that sets a minimum age for work. So because you have situations where an 8-year-old can be a nanny, can be a maid, and all of those things, 9, 10, 11-year-old children are working in those capacities. It's totally unfair. So this international best practices we talked about is not just limited to, in fact, you recall that I mentioned a case where the employee was HIV positive. That employee was a cleaner. And even in trying to do everything possible to assuage her, the court awarded about 5 million naira in her favor as compensation for the discrimination she suffered on account of being mistreated because she was HIV positive. That amount that was paid was more than 5 years worth of salaries that were ordinarily payable to her. I just don't want to exaggerate, but I think it was more than that. But the court just had to give that to at least compensate her for all the wrong. So everything we have discussed today applies to everybody, whether they are lower cadre employees, senior cadre employees, cleaners, nannies, and all those, applies to everyone equally.
Thank you so much. This has been very, very insightful. This has been a learning session on behalf of about over 90 people who joined at some point. We say thank you, and on behalf of many others who will watch later the recorded session, thank you so much. Again, you will come back. I
No problem.
By way of a special request and by way of a prophecy. Thank you so much.
Thank you so much.
Madam Ruth Abraye, we thank you for your time. We recognize you. Maybe you will come on this days and share some insight with us too. Please enjoy what is left of the evening. Thank you so much, sir.
Thank you so much. Thank you. Thank you. Thank you.